So thank you again, Professor Slynn, for joining us. And I'm now going to hand the floor over to your colleague, David Doorey, also of York University in Osgoode Hall, who will talk to us about another policy option on the table for us to wrestle with, that of non-majority collective voice in the workplace. So David, a warm welcome to you. Thank you so much for joining our assembly today.
Thank you. Thanks for having me. Can you hear me okay?
You're great.
All right. Hello, everyone. Thanks for spending your Saturday with this group talking labor law, which nothing excites us labor law geeks more than spending our weekend talking about labor law with a bunch of people who might be interested in it. So thanks for being here. So I'm going to talk about a couple of things here that might seem unrelated, but in my view, they build on one another. And the way I want to begin this is to, can you move to the second slide that I have here? I want to talk about, present you right at the beginning with two real life scenarios. And I say real life because the scenarios represent situations that have happened and to some extent demonstrate the philosophy and the scope of our existing labor law model when it comes to freedom of association and the right to act collectively. Is somebody controlling the slides? There we go. So in the first scenario, we have a group of non-union employees who are unhappy with their working conditions, okay? And I chose compensation in my example, but it could have been maybe they're not happy with their working hours. Maybe it's a harassing manager, something about the workplace they're not happy with. The point is they get together as a group sort of spontaneously, and they decide to approach their employer as a collective, okay, and express their concerns. So they go up to the employer and they say, you know, we're here because we're not happy with our working conditions. And the employer responds by firing them all, okay? Employer says, if you're not happy, then you can go find another job, okay? That's the first scenario I want to leave you with. Second scenario, it involves a large group of workers who have decided that they would like collective bargaining as opposed to individual bargaining, okay? And there's 50% of them. So half of the workers at a large factory in my scenario have joined the same union. So I picked Unifor and assumed it's like an auto parts company, okay? So then Unifor then contacts the employer and says, look, we represent half of your employees, and we would like you to sit down and begin to engage in collective bargaining with us about conditions of employment. And the employer simply ignores the union, doesn't even respond, okay? And so frustrated by the employer's response, some of the workers then walk off the job in protest, okay? They just go on strike. And the employer responds by firing all of those workers. Okay. Now, the questions raised by these scenarios are firstly, has the employer done anything unlawful in either of them? Okay. And then secondly, if there's no law being violated here and the employer is free to behave in the way I've explained, should these sorts of collective actions by employees be legally protected? Okay. I want to use those as examples, and we're gonna work our way through and come back to these when I get to the points I'm trying to get at, okay? But first of all, because I don't know exactly what you've covered off in the days to this point, I need to make sure we all understand a basic truth about the Canadian employment law model, okay? And that is that the starting assumption in Canadian employment law is that an employer is free to terminate a non-union employee at any time and for any reason at all, or no reason at all, okay? The employer might have to give that worker a warning, what we call notice of termination, but the employer doesn't need a reason to fire a non-union employee, okay? So that's the starting assumption in our legal model. And then there are some exceptions. One exception to the general rule that an employer can fire someone at any time and for any or no reason at all is if the employment contract says otherwise. So you could have an employment contract that says that the employer needs a reason to fire you, or a good reason. And that sort of clause is typically found in unionized collective agreements, where collective agreements say that the employer has to have just cause to terminate or discipline an employee. But you virtually never find a clause like that in a non-union employment contract. Maybe some executives Senior people have it, but your typical Walmart cashier or factory worker who in a non-union workplace is not going to have a clause in their contract that says that the employer needs just cause to terminate them. Okay, so those contract clauses requiring a reason are very rare in a non-union setting. Okay, the other exception is if the government has passed a law limiting the employer's right to fire an employee for a particular reason. Okay, and if we were in a classroom, I would ask for examples, if anyone knows any examples of situations where a law limits the right of an employer to terminate someone. But I'll give you the answer because I know that you know it, right? But there are lots of examples. For example, we know there are human rights legislation in Canada today that says you can't fire someone for certain designated reasons, such as race, religion, gender, and so forth. So that's one example. There are lots of statutes like employment standards legislation that prevents an employer from firing someone because they complained that their rights are being violated in the statute. So those are called anti-reprisal sections. Okay, you can't fire someone for joining a union. The reason being that labor relations legislation makes that illegal. Okay, so there are lots of examples of where statutes, laws passed by government, step in and say, you can't fire someone for this reason or some public policy reason. Okay, so as a general rule, non-union workers can lose their jobs, can be fired for any or no reason at all, unless there's a clause in the contract that says otherwise, and there hardly ever is, or there's a statute. The government has stepped in and said, for some public policy reason, you can't fire someone for that reason. Okay, we're going to keep that in the back of our mind as we move on. Okay, let's move to the next slide. Okay, so with that background in mind, then let's look again at scenario one. Okay, so the question that comes up is whether any Canadian law prevents an employer from terminating employees for acting collectively at work, right, in order to improve their working conditions. And the answer is no, right? The answer is that there is no legal right of workers to act together in association, to act collectively per se in Canada. Okay, they can be fired for doing so. So in our first scenario where a group of workers got together and approached their employer as a collective and complained about their working conditions and the workers were fired, there's nothing wrong. The employer's done nothing legally wrong. They may have done something morally wrong in your opinion, but they haven't violated any law, okay? Because there's no right to associate in Canada in the non-union setting, okay? Now, the law is not completely silent about the right of workers to act collectively at work because Canadian labor relations legislation, so collective bargaining legislation, protects a right of employees to engage in trade union activities, which I think you've already come across this idea so far in your sessions, okay? So we do have a right to engage in trade union activities, but we don't have a right to associate more generally, okay? So if a group of workers join a union and then the employer finds out about this and fires them, that would be illegal. Why? Because a statute says you can't do that, okay? But if the workers are not acting through a trade union, such as the situation in my scenario one, then that law protecting against trade union activities, discrimination based on trade union activities doesn't cover them, so they can be fired, okay? Now, this narrow law protecting against discrimination for trade union activities goes back to the 1940s in Canada. A few years earlier, the Americans had taken a different approach. They had introduced in their collective bargaining legislation in the 1930s a right to engage in concerted activities for mutual protection at work, okay? So can you, I think you've already talked about this, but you should be able to see the difference between the broader protection of a right to act collectively at work in the United States and a much more narrow right to engage in trade union activities in Canada, okay? So in the United States, that scenario, what the employer did in scenario one would be unlawful because those workers were acting in concert to try and improve their working conditions, okay? But in Canada, it would not be unlawful because they weren't doing it through the vehicle of a trade union, okay? I'll give you one more example that might have come up already, but in the United States, I think it has come up because there was a proposal for an app, I think, in one of your meetings, right? But in the United States, an employer can't fire workers for talking about their wages because that is collective activity. In Canada, it is perfectly fine for an employer to fire employees because they are talking amongst themselves about their wages. Okay, so the first issue then that we have to think about, and again, I think you've already gone through this, is whether Canada should adopt some form of a right of workers to act collectively. It could be an individual right to engage in concerted activities like they have in the United States, or it could be a standalone right to associate. The point would be that the law. I'm getting some feedback here. The point would be that the law protects workers from some sort of reprisals if they join together, right, to try and improve their conditions. Okay, so that's the first scenario that I wanted to raise. And on my mind, this is talking about the foundational right of workers to act as a group, which we don't have a protection for that in Canada. Okay, then if I can have the next slide, the final slide. If we then pull back our lens from an individual right to act collectively, we now have scenario 2, in which a large group of workers, 50% of employees in my scenario, or 1,000 out of 2,000, want collective bargaining. So they join together as a group, and they all joined the same union in my scenario, okay? And it was I used an auto parts plant, so I said it was Unifor. Okay, that's just the example I chose. This is based loosely on a sort of failed organizing campaign by Unifor at a Toyota factory out in Cambridge. Okay, the point is, a large group of these workers at this factory come together. They want to have their working conditions determined by collective bargaining instead of individual bargaining. They join the same union, and the union, Unifor, in my scenario, goes up to the employer and says, we represent half your workers. We would like to begin collective bargaining. And the employer says, employer basically just ignores the union, right? Doesn't even respond, okay? And then in frustration, some of those workers go off on a strike. They do a walkout, and the employer fires them all. And again, I'm getting at this question of whether the employer has done anything wrong, okay? Now, if the employer fires these people because they joined Unifor, that would be illegal because, as I've said, the labor relations legislation already protects a right to join a union and also to engage in protected legal union activities, okay? But on my scenario that I gave you here, because our system is based on majority rules, as I think you've already learned, Unifor has no legal rights. Okay, no legal rights to collective bargaining. So when the employer says, or when the employer hears, Unifor says we represent half your workers, half is less than a majority. Okay, I could have picked 40%, I could have picked 30%, but in my scenario I said 50%. That's less than a majority. The union needs 50% plus 1. Okay, the point of it is, in our legal model that's based on majority rules, it's all or nothing. Either the union represents a majority, in which case it gets access to a bundle of rights, including an obligation on the employer to sit down and bargain in good faith with the union, and also a limited but protected right of the workers to strike. Okay, that's true only if it's a majority union. In other words, the union has been able to prove to the employer and to the government that it represents a majority of the workers at the workplace. Okay, but if the union can't show that, so in our scenario, the Unifor is unable to show a majority support. The union doesn't get these access to these rights. It gets nothing. The employer has no obligation to recognize or bargain with Unifor. The workers do not have a legal right to strike. And so when the employer fires them for striking, that's probably okay. Again, all that's happening there is that a bunch of non-union workers have just not shown up for work one day. Right? There's no legal right to strike in Canada to pressure your employer to bargain collectively, right? You need a majority support. So the policy question that arises from this situation is, should Canadian labor law recognize some form of collective bargaining, protected collective bargaining rights, where a union has, some level of support, but not a majority, right? So in other words, should we do away with we're not do away with, that's just one of the questions. Do we keep the majority rules model? So if you get a majority, you get all these rights. But if you don't have a majority, you get all or some of those rights, right? In other words, maybe if the union, I'm going to wrap up in 1 second because I know I'm out of time, I think, but maybe if the union has, say, 30%, right? Or 35 or 40, whatever you want to put it at, some level of support, short of a majority, that the employer still has an obligation to meet and negotiate with that union in respect of the employees it represents. In other words, if there's no one majority union, then the employer has to bargain with any other minority union that has a significant level of support, right? But then there are tricky questions that we have to think about, right? Including like, to what does the minority union that represents 30% get all of the rights that are traditionally granted only to majority unions? Do the employees in the minority union have a full protected right to strike in the same way that employees in a majority union do? These are questions that we would have to think about if we were to move down the road of thinking about some sort of legal model that recognizes not just majority unions, but also non-majority unions, right? And there are some tricky policy questions, but these are the sorts of things that those of us in the field are thinking about. Okay, that's a really quick rundown of some really complicated questions, but I'll stop there.
Thank you so much, David. That was really helpful to pose some of those questions that our members might be wrestling with in terms of how far to go with this. Let me immediately turn it over to any questions that might be coming in. Please feel free to put comments in the chat, raise your Zoom hand if you do have a question, or of course you're welcome to put a question in the chat as well. I'll look for some Zoom hands. Maybe while I'm waiting for the first question to come in, David, if I could just ask you to clarify one thing. When you were identifying some of the gaps in terms of the laws and statutes on the books, and thinking about this fundamental right to associate, you mentioned at the federal level. Is there also a provincial jurisdiction of this, or how would you weigh that? And then Amir, I see your hand is up next.
Richie, I'm not sure if I followed the question, but our jurisdiction over whether it's federal government or provincial government is already pretty set out in the law. So most workers, like 90% of them are covered by provincial law. So for the most part, we're thinking about how provincial governments would think about reforming their provincial labor laws, but the federal government as well for the 10% or so of workers that fall within the federal sector. But we're talking about really sort of reforming labor collective bargaining legislation to deal with these two questions of protection for a right to associate and this sort of thorny question of non-majority collective bargaining.
Okay, wonderful, thanks. I just wanted to make sure that was clear for any members who want to pursue this as a policy recommendation, what actors they might impose upon. I have Amir, your hand is up, and then is that, I can't see there's another hand up here, but Amir, you go first.
Yeah, I have a couple of questions. One is, for example, it's the Toyota. Now, the problem is with the mechanics or the technical people. Now, they want to form a union. And 50% means the whole employees. Or is it the union which is going to represent only the technical people?
So the way our model works is the union picks a grouping of workers that it wants to represent, which we call the bargaining unit. And it's sort of the typical way it works is you're dealing with, as Professor Slynn said, we're usually dealing with an enterprise level in Canada. So a factory or an office or store. So in my scenario of an auto parts factory, you'd be looking at probably a bargaining unit of people who work in the factory. But it might exclude, it would probably exclude office employees, and it would exclude certain managers and salespeople and so forth, right? So in our normal labor law process that we've used since the 1940s, the labor board has to sort of define what's the proper bargaining unit, and we would still have to do that in this model. So it would be, what group of workers is the union trying to represent? We still have to figure that out, but we have to figure that out now anyways. But there could be issues that come up in a minority system where the union is, the 30% of workers that it's representing are kind of across a whole bunch of job categories. And there could be a question of whether that's an appropriate grouping of workers that the labor board would have to sort out. But we do have a lot of experience of dealing with those sorts of questions. It's a kind of a boring area of the law, but it's a really important area of the law. What is the group of workers we're talking about? It's very important in a system that involves majority rules, for sure. You need to know what the denominator is in the fraction.
To continue, if it was an individual who is actually fighting for something, and he is fired on some other pretext rather than actually what he's fighting for, so does the anti-reprisal law still apply for him?
So, we're talking today about collective bargaining rights, which usually implies a collective, right? So more than one worker. So we're talking about what happens if two or more employees come together and act collectively to try and improve their lot in life. If it's just one employee, then we're not really into collective bargaining anymore. We're into the individual rights at work. So that raises a whole other question, right? Of whether, you probably are dealing with this in other modules, but
But usually without a union, the point starts there only, right?
Usually what? Sorry, I missed that.
The foundation of a union starts there only, right? When somebody faces that situation and he starts arguing about that.
Oh, so you're saying an individual worker says, expresses interest in joining a union?
No, an individual, he is actually expressing some, what do we say, some disagreement with some things going wrong, and then it goes to a union, forming a union, right?
Well, this is an interesting. This is an interesting question, right? In the way you would describe it there's no union on the scene yet.
Yes, that is at that point. Can he still go for anti-reprisal law if he is fired?
Not usually, no. I mean, the person would have to argue that you have to bring yourself within the scope of that word trade union activities, that phrase trade union activities. Okay. So you would have to say, I hadn't joined a union yet, but I was thinking about it and the employer knew I was thinking about it. And therefore this is still discrimination on the basis of trade union activities. But it's a bit trickier if it's just one individual unhappy worker that expresses their concern and they haven't thought about a union yet.
Okay.
Then you really need one of those laws that that we have in the federal sector and in Quebec and Nova Scotia that says the employer has to have a reason to fire someone.
Yeah, because I'm trying to establish the fact of origination of unions, because where I see problem is the forming of unions. The concept of forming of union is lacking because of this fear only. Anyway, I'll not prolong. Thank you.
Well, we do have, just to be clear, the law does, labor relations legislation already does prevent an employer from firing someone for trying to organize a union. Right. That's already there. But the question you're getting at is what if it's kind of before that? What if it's this?
Yes.
No one's talked about a union yet.
Yes.
Then it's a bit trickier to see if you can fit within that prohibition.
I'm just gonna jump in here. We've got time for one more question, and I see Abel has raised his hand, and I know some of your questions, Mohammed, will be good to wrestle with when you get into your smaller breakout groups. So. Abel, let me go ahead and hand it over to you for one final question for David.
Right, thank you very much, Richard. My question is this: if in an automotive industry where a section of the employees working in a more hazardous environment than others, and they decided that because they face more dangerous working condition, that they require certain kind of better work package. And they decided to, engage the management about that. without being members part of the union. I think the old rule of firing them needs to be kind of amended, because even if they are fired, the problem is still there. And whatever comes up, the problem still persists. So I think that particular law, ab initio, need to be updated so that unionism might not really affect how people work, but the internal management structure of a company determines how people work, because if they're not happy, it will affect their output. So is there a way of getting that in the future where those kind of laws will be updated?
Well, so in your scenario, if a group of workers come together and complain about the safety of the workplace, you may be into protections that already exist under occupational health and safety legislation, which I'm not sure if you've talked about, but there is legislation, occupational health and safety legislation, that includes anti-reprisal protections. So in other words, if a group of workers complain, so that legislation requires the employer to maintain a safe workplace. And if a group of workers approach the employer and tell them that they are, suggest that they are not maintaining a safe workplace, then the occupational health and safety legislation may prevent the employer from firing those workers or discriminating against them. So there's an exception to what I was saying about how there's no protection. Sometimes there's a statute, an anti-reprisal statute, that says you can't fire workers who raise concerns about non-compliance with occupational health and safety legislation, right? So that's one narrow example of where a right to act collectively is protected in regards to health and safety. Now you raise some broader issues there, but on the narrow question of the scenario you gave me, there could be a statute that protects those people if it raises to the level of a dangerous workplace. But at a more general level, the employer wouldn't, if it's not an occupational health and safety measure, then one of the most famous cases about the right to act collectively in the United States involved an unsafe workplace, where the workers said, "Oh, this isn't, not safe here," and they just walked off on strike, non-union, and that was considered protective collective activity, whereas in Canada that would not be. So it's all part of this big question here about protecting. I think the idea of everything that I've been talking about here is the idea that maybe we ought to think about the fact that workers should be able to voice collective concerns without fear of reprisals. And then the question becomes, how do we do that through a legal model? Right now, it's mostly trade union activities and the occasional statutory protections such as occupational health and safety if it deals with safety issues. But as a general rule, we don't have much protection for workers who come together and express collective concerns about the workplace. There's not much protection for collective voice outside of formal majority trade unionism.
All right. Well, thank you so much, David. Let me jump in there and just on behalf of all the members, thank you so much for that presentation.